Speakers have it arrived. So, our first speaker today, many of you may already know, is Crumley from the University of Liverpool, and he's going to be talking about property in the first-tier tribunal. He'll have a 15-minute presentation, time for questions at the end, but hopefully the other speakers might have arrived by then. So, Brett, you can start when you're ready.
Hello everyone, I'm Brett, as most of you know. Today I'm going to talk about property in the first-tier tribunal charity. The first-tier tribunal charity is one body of two bodies which comprise the charity tribunal. Because all the cases I will talk to you today were heard in the first-tier tribunal, I will just refer to the body as the charity tribunal or the tribunal. So in this paper, I will first state my argument, then I will go through my research findings. I shall explain what I think is a problem with the charity tribunal's property jurisdiction and explain what I think might be a possible solution to that problem. And then I will highlight two assumptions which I make throughout the presentation, try to explain why I think they're acceptable assumptions to make, and then I will offer some conclusions. The argument is a work in progress. I'll appreciate any questions or comments at the end. And the references are quite long, so I've put them in a reference slide at the end of the paper slideshow, rather than cluttering each individual slide. So, my argument, the charity tribunal's jurisdiction should be expanded to allow it to fully develop and coherently develop charity law, in particular the property aspects of charity law. The charity tribunal currently has quite a narrow jurisdiction, and this may preclude a full development of charity law. Charity Tribunal is a recent body created by the 2006 Charities Act, and one of the intentions of creating the Charity Tribunal was to allow it to develop charity law and to enhance access to justice. But if the legislative framework of the tribunal precludes the full development of charity law, then there may be a fundamental conflict in the way that the tribunal is set up. And in relation to property issues, at least, a solution to this problem may be in giving the charity tribunal a power to refer questions to itself, so that if it lacks the jurisdiction to hear the question and determine the answer in an ordinary appeal or review, it may nonetheless provide an answer in a reference. So, the research findings. I've gone through all the charity tribunal decisions and categorized all the cases about property under three broad classes. So there are cases about the necessity for charities to have property. There are cases about the control and appropriate control of charity property by charities, and there are cases about the use to which charity property can be put. So in the first class of necessity, charities need property to exist. In the LASPA decision, the tribunal decided that a potential claim to property is not sufficient property or does not constitute property at all to allow a charity which only has a potential claim to remain registered as a charity. The Charity Commission maintains a register of charities, and under Section 34, the Commission has a duty to remove any institution from the register if it ceases to be or does not operate as a charity. The LASPA decision confirmed that if a charity has no property, it has ceased to be a charity and must be removed. Now, in that case, the tribunal sympathetically gave the charity 6 months to either take its claim further and show some prospects of success in the High Court to regain its property, which it lost, or to find some other property. The second category, control of charity property. Appropriate persons must control charity property, and the tribunal takes a protectionist strategy to ensure that charity property is looked after property and applied to the purposes that it is supposed to be applied to. In the Bath Recreation Ground decision, the tribunal decided, or confirmed rather, that trustees of a charity cannot act with a conflict of interest. In Bath Recreation Ground, there was a plot of land and there had been some potential breaches of trust, and the commission created a new scheme for the administration of the charity. In that scheme, it allowed for 2 trustees to be selected from the local council. However, those members of the council could then elect further trustees. The potential breaches of trust may have been made in a situation where there was a conflict of interest between the council and the charity, because the charity land could be used to provide services which, if provided by the charity, would not have to be provided by the council. The tribunal decided that the scheme should be amended so that only 1 member of the Board of Trustees could be selected from the local council, and they would not have a power to either be the chair of any decisions taken where there could be a conflict of interest. Yes, and another case under the control category is that title may be transferred from charity property for the efficient administration of a charity. So under Section 69 of the Charities Act 2011, the tribunal, or the commission rather, shares a concurrent jurisdiction with the High Court to create administrative schemes. And Bartley confirmed that if a scheme is proposed by the commission to put the legal title of 2 charities' property into a single company's hands so that that single company could administer both charities, then that is acceptable. And I'll take you to a quote from the case. It is plain from the wording of Section 69, subsection 1, that a scheme may provide for the transfer or vesting of property. Section 70 limits the Commission's jurisdiction in this regard, in that a scheme may not be used as a means of resolving a dispute about property ownership between a charity and a third party. The tribunal said this because in the argument, it was suggested that by transferring or vesting the legal title to the 2 charities' property in the company would resolve a dispute about who held or whose title it was. And the tribunal confirmed sensibly that when Section 69 is engaged, Section 69 does not conflict with Section 71. And title can be transferred for the administration of property in an effective manner, and that when that happens, the only thing that is happening is a recognition of existing rights. And if there is any dispute about the title to the property, then that must be disputed in the High Court. Under the 3rd category of property, there is the use of charity property. Property may only be applied to further charitable purposes. So a charity is a trust that is created for exclusively charitable purposes. If those purposes become obsolete or redundant, the purposes may be changed. This occurs under the doctrine of si pre. In Bath Recreation Ground again, the tribunal allowed the charity's purposes for a part of the land, for a part of the recreation ground, to be changed temporarily because it was in the charity's best long-term interests. Now, the charitable purposes of the Bath Recreation Ground were to provide an open space for the playing of sport, which did not favour any particular sport. And one of the potential breaches of trust in that case was the building of a leisure centre. Now, a leisure centre, while it provides sporting facilities, does not provide open-air sporting facilities. The tribunal decided that it was best to change the purposes of that part of the land on which the leisure centre was built to allow the provision of indoor sporting facilities until the life of the leisure centre has expired. And at that point, the purposes would revert. So there are some of the things the Charity Tribunal has contributed to charity law and clarified or qualified aspects of charity law. But there are also missed opportunities. So the tribunal lacks jurisdiction to try or determine legal or equitable title. So under section 71, which was engaged in Bartley, if the commission creates a scheme under section 69, it cannot do so as an attempt to try or determine who holds legal or equitable title. Also in Bath Recreation Ground, the tribunal confirmed that it cannot determine the validity of a lease. So while the tribunal has developed property law in some aspects, it has had to refuse to answer questions and thereby develop aspects of charity law in other respects. In Keno, the tribunal was unable to consider the operation of section 105, which is a power for the commission to authorize dealings with charity property. And the tribunal had to refuse to answer a question about section 105 because the applicant who brought the appeal had failed to evidence a request actually for a section 105 order. If an applicant does not ask the commission for a 105 order, there is no way for the commission to have refused a section 105 order. Because there was no refusal, there was no decision which the tribunal could attempt to change or support or alter. Under the Charities Act 2011, sections 325 and 326, there was a power for the Commission and the Attorney General to refer questions about property law to the tribunal for an answer. Under section 325, the Commission may refer any question about property law that is raised in the operation or exercising of its functions with the Attorney General's consent. Under section 326, the Attorney General can refer any question of charity law without anybody else's consent. So my argument is that if the tribunal were given a similar power to the Attorney General's under section 326, it would be able to refer questions which are raised in its appeals or reviews, which it has to, at the time, refuse to answer. And although the tribunal probably should not have a power to try or determine legal or equitable title, or to determine the validity of a lease, it perhaps should have the power to develop aspects of property which potential litigants are unclear about, for example, section 105. Now, it's important to note, and it was implied in what I've already said, but I didn't explicate it, that the tribunal on appeal can only make an order which the Commission was empowered to make. If the tribunal were given a power similar to the Commission's under section 325, it would similarly only have jurisdiction to refer questions which would be raised in the Commission's exercising of its functions. So to give the tribunal a power similar to the power in section 325 wouldn't really give the tribunal much more power than it has today, because it is already limited to answer questions on appeal by the Charity Commission's remit. Whereas under section 326, sorry, if the tribunal were given a power similar to that provision, it could refer questions to itself without anybody else's consent. So I say this argument is a work in progress. One of the things I have to consider is the potential safeguards that would have to be would have to influence that provision, because the tribunal may have to, for example, seek the upper tribunal's consent to refer questions to itself, or have a quorum of 2 judges as a minimum to refer questions to itself. And these are things I'm going to consider next. So the 2 assumptions that I've made. First, that the Charity Tribunal is a good candidate for developing charity law, including the property aspects of charity law. And while I've assumed that the Charity Tribunal is a good candidate for this role, it's not a wild assumption because the tribunal was created with the express goal of developing charity law. So whether it is a good candidate or not, it already has that power. It is just a limited power. And the second assumption is that there are unknown and unforeseeable, yet important questions about charities and property that the tribunal should answer, but cannot answer under its current legislative framework. So I've shown that there are some questions that the tribunal has had to refuse to answer, and hopefully shown that there are some questions, such as the operation of Section 105, which the tribunal might be wise to be able to answer. In conclusion, the tribunal has developed, contributed to, or clarified some aspects of property in charity law, but its jurisdiction has prevented the analysis of some issues. So it is possible that it will have to refuse to answer other questions in the future, but it is impossible to know how significant or important those questions it will have to ignore will be. If the tribunal were given power to refer questions to itself to give an answer, then it could resolve problems that are currently unforeseeable, which may arise in the future through its appeal decisions. Thank you.
Thank you, Brett. So I take it Jonathan Brown or Caroline Bergen-Cross in the room? No? Well, our next speaker then is Renato Lovato Neto, and he's talking about the compensation of danno biologico under Brazilian tort law. So we'll just get that set up.
Do you want to? Have you got slides?
It's okay.
Yeah. That's fine. Give you the mic. That will work there.
Oh, okay. Well, very sorry for my delay. I lost my connection in Birmingham, so but I'm here. Good morning, first of all. My name is Renato Lovato Neto. I'm from Brazil and doing my PhD in Porto, in University of Porto. And well, it's an honor to be here. My theme is about a new head of damage that's been developed in Italian law since the mid-70s, but it was first accepted by the Corte Costituzionale in 1986 by the decision number 184, and it's a very interesting head of damage that I've been studying. That is quite new and quite it's not used. The idea is not know it in Brazil under Brazilian law. It's the concept is basically the psychological and physical injury that is not covered by accident that not results in any kind of loss of labor or work capacity, and it was it was developed in Italian law because they had a obstacle in the article number 2059 in the Codice Civile or the Italian Civil Code, and they couldn't support non-patrimonial damages that was not typically provided by law. So usually they had to be described in the penal code. So the doctrine start to develop this theory about the danno biologico, and it's a very because the compensation was very low. So that was the problem in the 70s under Italian law, and I think that became a very hard problem in Brazil because we have a lot of difference in compensations and a lot of some kind of discrepancy in because we have some tort actions that results in a very low compensations and another one that got some high value of high amount of damages. And I think that's a very interesting idea to develop in under Brazilian law. We only got a very old law that prescribe personal damages for accidents by vehicle, but it's not a tort and it's not a head of damage. It's just a mandatory insurance that's provided by the Brazilian government. It's called DPVAT. It's a mandatory insurance for that covers almost £3,000 for personal damage, including those damages that are like medical and other expenses that like to adapt to the new home or something that are related to disability that can result from a automobile accident. So under the Italian law, that was a very long process, a very long development. And first of all, it was assumed that as by the Constitutional Court, it was assumed as a head of damage, but it's tertium generis. That was not patrimonial, that was not non-patrimonial because it had characteristics of them both. And the further developments stated that should be damage that's equal for everyone, and had some characteristics of non-patrimonial and patrimonial damage, but also the most interesting thing is that should be equal for everyone. It doesn't matter the gender or it should be a female or male. Doesn't change very much. And the only thing that should be careful for should be important for the judge to pursue the value of the compensation should be the age and the proportional and the disability that results from the action of the plaintiff. And sorry, and the further developments stated that under the Italian law, it results in the tabella di Milano, which last year was assumed by the La Cassazione, sorry, that should be the usual the mandatory table to verify this danno biologico. The danno biologico, it involves a lot of interested that comes from the health and the integrity of the body and the psychological sphere of the individual, and it involves the sexual damage, the existential damage, and it is development authorize the Italian doctrine pursued a lot of another head of damages that are basically founded in the fundamental rights that are 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 described in the Constitution. And I think that's something. It's very close to what happened in Brazil, because we got a new constitution in the late 80s that changed quite a bit the private law, and we started to protect the interest described in the constitution as head of damages. So it's very close to the German doctrine of legal protecting interest that's influenced a lot of the civil code in Portugal. But in Brazil, we are influenced by the French and the Italian doctrine that are very they're just they don't we don't have like a close clause of tort law. We just we don't pursue interested legal interested protected legal interested. We just have some abstract ideas of what is damage. So I think that influence when we are found in the constitution to pursue the new heads of damage. I think that should be something that we should consider when we think applying the danno biologico in Brazil, and also in Italian law and also in Portugal law, Portuguese law. Sorry, we started to the this legal atmosphere conducted to the usage of the stables, like I said, the tabella di Milano, and under the Portuguese law they developed a table that described the disability and the age of the people, and we can use this influence, this experience to apply something or to develop something like that in Brazil. And because the idea of this biological damage is applied by some courts, but not with some with not a regular approach. It's a very we have a lot of difference from court to court and from state to state, and they are not equalized in the superior courts. They are just stated as that. So we have in the most high court, we have different approaches to similar similar situations. And in Portugal, as they are using some tables since 2006, 2007. They have a more regular approach to the problem. And I think to conclude the biological damage is, I think it's a very interesting head of damage to develop under the Brazilian law. We don't have nothing like that, and it's not covered by the disability that caused loss of work capacity. And I think that maybe it's a new approach to problems that we are the courts are ignoring that we have this idea that's the same thing, the same problem, the same injury to interests that are basically the same. The first approach to by the Corte Costituzionale in Italian, they apply the article number 22 from the Constitution, that describe the legal, the fundamental right to health. And we have all those fundamentals in Portugal under the Article 25 and Article 24 that stated the fundamental rights to health and body integrity. And in Brazil, we have the article number 6 that also provided the fundamental right of to health. And under the civil code, we got the body, the name as personality rights. And I think that we have all those fundamentals to pursue a full protection to health. And it's a very interesting idea to use. I think in Europe, they around 2004, 2005, it was a state a barometer to prevent those inequality of the amounts of damages. So I think all those ideas should be thought about, should be think in some kind of useful proposed to Brazilian law. And because the tables doesn't ignore the fact that some damage should be personalized, should be individualized to the damaged person, because they doesn't ignore another head of damage. It's just one of the damage that should be compensable with moral damage, with another non-patrimonial damages, and another patrimonial damage that can be happen. And I think that should be something that we can use in Brazil and make a less unequal tort law in the direction of justice and to protect this very basically fundamental right that is health and body integrity. So I think that maybe we can use this experience from the Tabella di Milano, from the private law evaluation tables from Portugal, and also the experience from the danno corporale in Spain, and also from France. But I think this corporal damages just involved also the biological damage, and that's more related to these fundamental aspects and from the protection of fundamental rights in the Constitution. So I think that's basically what I could tell. I hope that it was useful. Thank you very much.
So we've given that we've two of the speakers aren't here. We've got plenty of time for questions, but for that reason, I don't propose we spend 40 minutes asking questions. But if anybody's got any, John.
I've got 2 questions, Craig. I hope that's not abusing
that's
my
fine.
First of all, I'm not a property lawyer or a charity lawyer, Brett, so I'm going to blunder into this question. It may sound ridiculous. You said that it was important. You feel it's important for the charity tribunal to have the power to self-refer. And I was wondering whether you'd considered the sort of practicalities of that. Like, when would that happen? When is it going to be the case? Is it the case that the charity tribunal would say, as a thought experiment, the judges are sitting around having coffee and they think, oh, wouldn't it be interesting if such and such happened? What would we do? Is that the sort of self-referral you're talking about? Or is it the case that a case comes before the tribunal, in which case it would seem to me that the power of self-referring is redundant? So I'd be interested to hear what you say on that. But my second question, I am a tort lawyer, so I can answer, or at least I can ask this question, but I am an English lawyer, not a Brazilian one. So again, I may sound ridiculous for different reasons. The question I had, I guess this depends on whether you can, what your understanding of the English position is. And I guess you haven't thought about it, but in English law, we have this distinction between specific damages, where you're compensating someone who perhaps can't go to work anymore because they've been so badly injured. And then we have general damages, which relate to this pain, suffering, and loss of immunity. Am I right in saying that this doctrine you're referring to covers those damages, the latter, pain, suffering, and loss of immunity, and not the specific damages? So what I mean is, if someone has had quite a serious injury and they've suffered a lot of pain as a result of that, are you saying that this doctrine provides compensation for the pain rather than for the loss of earnings or loss of earning capacity? Does that make sense? And I'm just keen to establish where this fits in the law of damages in Brazil.
Okay, so Brett first.
Thank you, John. I think it would be a step too far to allow the tribunal a power to refer questions to itself generally. So perhaps a power to refer questions to itself which are raised during appeals, which it has to refuse jurisdiction at the time because the applicant has failed in some respects to establish their standing. But at the same time, you might be right, if the tribunal were just given a jurisdiction to follow issues through, notwithstanding an applicant's lack of standing, that might resolve the problem in the same way. This has happened in one case. Harrogate Fair Trade Shop. A shop wanted to become a charity. They didn't establish charitable purposes. The Charity Commission said, we can't register you as a charity for you to be able to get tax advantages as a shop without charitable purposes. They said, if HMRC show that you are allowed to have those tax advantages, we may be able to register you then. So then they went to HMRC, who said, we can give you the tax advantages if the commission registers you as a charity. So they were stuck in a bit of a loophole. The tribunal recognised that this was just a sort of an impossible situation, and said, here is a structure that you might want to follow. Function as a shop, open a sister charity into which you funnel your profits, and then you can get the tax advantages on the profits that you funnel into the charity, but then still be able to function as a shop for other administrative purposes. So it is sympathetic in situations like that. So it's something to consider. So thank you.
And Renato, do you have a response to John's?
So, I think that's the most interesting thing of this idea of danno biologico, because it's not related to the laws of work capacity. But I think that is, from what I know, it's not exactly the same of the laws of managed damage. And it's a very specific thing that it's not cover the non-patrimonial damages. It's just the disability that results from the damage to the health and to the body integrity. It's not a huge amount, but it can solve problems, as in Brazil, because that we got a huge expand of the idea of moral damage that came from the Italian law, but the doctrine that came from the 70s. And under the Brazilian law, it was stated that everything that was not patrimonial, it was moral damage. And also pain, suffering, everything, it's moral damage, not just damage to moral integrity. Everything that's psychological, everything that's suffering results in moral damage. Like static damage, sexual damage, everything, loss of chance, everything is moral damage. And the one of the things that happened in Italian because of the development of the danno biologico was the separation of the moral damages as subjective non-patrimonial damages and the other objectivist objectives damage. One of that is the existence of the danno biologico that became a kind of damage that's equal to everyone and can be can be um, can be awarded together with another very subjectivist damage. So I don't think that's just a separation of one of those. It's just a new understand of things that are just separate, and normally usually they are awarded in a very low rate. They were in Portugal, they were in in Italian, and because usually they use the tables of compensation that usually are used to in by work disability caused by work accident. So it's I think it's a very it's not the same as I think the laws of man. But it's a separation of everything that becomes a disability that results in loss of work capacity of earnings.
Okay,
So-
I think we've got other questions. Yeah. No, you can.
Well, no, just a consideration about danno biologico well, about Italian law. Well, in reality, well, I think we have like three categories of damages: the pure patrimonial ones, the danno biologico, and then the danno non patrimoniale, which is that you pay for the suffering, also the moral pain because and the category of danno biologico exists because it is a way to standardize an evaluation, which is in reality very complicated, because how can you establish a price for the moral suffering and is a problem that is caused by the evolution of private law that goes beyond its traditional borders, which are money basically, to dealing with feelings and impacts on and the danno biologico, because it's made following tables, and when you work in a law firm, basically what you do is you take the report of the medical practitioner and you have a sort of calculator, and they calculate the percentage of invalidity and thus the money you get. Of course, it's not in line with what the real suffering is or may be, but it needs, especially in the extrajudicial transition, the extrajudicial practice, which is very frequent in case of car accidents, for example. It gives you the possibility of going faster and without controversies with the counterpart. It's a huge simplification. But normally you say, well, okay, I send you a letter, say this is the table, I made this, pay this. If not, we go to court. If we go to court, normally, besides the danno biologico and the standardized price, you get also, well, you begin discussing about moral pain, I want more money, but it is a thing for lawyers, and in Italy it may last 6-7 years. So, but it's not probably a question, but it does.
Okay. Do you have a response to that?
No, I think that was very conclusive.
Okay.
To summarize all the ideas.
No, but it's
Okay.
really interesting that you are trying to implement in Brazil something we had so much thinking about, and you know that also in Italian law, the case law is always like is not crystal clear. Every judicial decision changes.
Yeah, I saw that we have a lot of you have a lot of decisions and it's still developing and it's still the tabella di Milano is every year is updated and I think that's something that we can take it some advantage of this development because we have a long tort law actions also that in conclusion came to sometimes to nothing or very reduced uh, awards of them. So I think that's something that we can use. Thank you.
Harriet.
My question was for Brett. I think it relates mostly to your first of your two assumptions, I think. But it seems that you're trying to, it's not extending the jurisdiction of the tribunal, but it's trying to widen the range of things that it can consider, even if it's not in relation to jurisdiction of a specific case. This reference would allow it to give an opinion on something else. Are these not questions that can be considered by another court? So things like validity of a lease, and if they can be considered by another court, then what's the benefit of having the tribunal consider them when we've already got a court that can hear these sorts of issues? I know you did exclude validity of a lease, but I'm wondering if that's an example of the kind of thing they are actually looking to exclude, just things that are already in the jurisdiction of another court. And what, if that's the case, what's the benefit of having the tribunal look at them rather than the court?
Okay, thank you, Harriet. Yes, the High Court can answer any question that the tribunal can answer. In relation to reviews of reviewable matters, which is essentially a judicial review by the tribunal of something the Commission has done, the tribunal has decided or said, but it's more of a clarification or a qualification, that if there is a procedure in place to appeal something to the tribunal or have the tribunal review an issue, you can't try to go to the High Court first until you've gone through the tribunal, because there is already a mechanism in place for it. So the High Court can answer any question the tribunal can answer, but if there's a procedure for the tribunal to answer it, the tribunal must answer it first, unless it wouldn't be able to give a proper remedy, in which case it might refer it straight up. Yes, so the determination of the validity of a lease or the determination of legal or equitable title, I think that is well beyond the tribunal's jurisdiction. And the tribunal was created partly because charities and relevant litigants were dissuaded from litigating in the High Court because of the expense and for other reasons. So the tribunal was created to provide a mechanism for charities to have issues adjudicated. If it lacks the jurisdiction to hear questions that are brought before it, for example, the operation of Section 105, which the charity probably can't afford to take to the High Court, then there's a disconnect between its ability to provide access to justice and then to develop the law through that mechanism. So I think it's probably that sort of problem that I think might be able to be addressed through giving the power, the tribunal question to refer questions to itself, or just expanding its scope to recognise that if a question is brought on appeal and it would otherwise lack the jurisdiction, for it to be able to give an opinion. Is that adequate?
Answers the question. I think it raises another one.
We'll come back to that. John's got one.
Maybe it's tricky. So what does the tribunal do when it doesn't have jurisdiction? Does it just sort of continue to pontificate like a court would, or does it just say, "I'm going to stop now. I've got a follow up on that"?
Okay. Generally, first on appeal, if an applicant tries to appeal a decision, order or direction of the Commission, it must identify a relevant decision, order or direction and then show that they have standing. So the tribunal will first state whether a relevant decision, order or direction has indeed been identified, and then whether the person bringing the appeal falls within the persons with standing. And in the deliberation of whether a decision, order or direction has been identified, goes into some detail in some cases. And in stating or in identifying whether the person bringing the appeal has standing, it can go into some detail. But once it has said a relevant decision, order, or direction has not been identified, or that the person bringing the appeal does not have standing, it stops there. But it can then ask for representations from the parties before the case is struck out. And in those representations, the applicant is given another opportunity to clarify its legal argument, because most of the applicants are litigants in person. When those representations are presented, the tribunal can then give another response if it's necessary on those representations. So there are opportunities for it to continue to pontificate. But you've got to be, as a litigant, very clever to make the tribunal give an answer under the legislative framework, however sympathetic the tribunal is. Once a person does not have standing, the case has got to be struck out.
Before we come to Harriet and John's follow-up questions, can I just see how many other people have questions? Okay, so we'll do Harriet's follow-up question, John's follow-up question, and then you can be the last question. No worries. Harriet.
So, from what you said before, if we go back,
Okay.
it seems that you want the tribunal to have jurisdiction to answer these questions, or at least somehow to consider these issues, because charities won't go to court because they can't afford it.
Yes.
So doesn't this seem like a really sort of roundabout way of fixing the fact that the charities can't afford to go to court, when really they should just go to court, but we should have some mechanism to allow them to go to court?
Yes. In fact, in the Harrogate Fair Trade Shop case, the advice the tribunal gave to the shop was advice that a charity lawyer could have easily given, but it's the charities have got to go to a lawyer, whereas and pay probably, whereas the tribunal is free. And it may be, this is something I'm going to have to consider in the empirical part of this research. May be the case that charities see the tribunal as a provision of legal advice, because with this sort of disintegration of some services in the welfare state, charities have taken up that the lack of certain welfare services, and it may be perceived that the government has provided a tribunal to facilitate the work that the charities are providing because the government no longer provides those services. But that goes into failure theory, and it relies on the idea that charities provide services that the market or the government fails to provide for some other reason. So, if the tribunal is perceived as a mechanism to get legal advice, then there's a problem, a big problem there. And actually the solution might be to provide some sort of services, some sort of service to allow charity litigants to go to the High Court. It has been suggested that all charities are taxed, and then not taxed, but they pay a fee, and then that provides a big part for all charity litigation, but this was rejected. And yeah, I hope that answers your question.
John.
So it seems like we're doing, as a jurisdiction, are doing a lot of work for charities. So first of all, we set them up a tribunal. Then it's got special referral mechanisms already, isn't it? Because the Attorney General can refer issues to it, points of law issues, with clarification. And then you're proposing it would have another special power to refer points of law issues to itself. Why are we doing so much work for charities? Why is there anything sort of special about them that would justify this in relation to other types of tribunals, areas of law?
That's a very good question. I suppose it goes to the core of charities, I think, because charities are already given quite a few advantages in law. And this would the tribunal is another advantage, that they have essentially free litigation facilities for certain questions. As for justifying why charities should have the extra advantage, it's something I'll consider. I'm not sure if I can answer it today. If it is, if it was implemented in the charity tribunal and it was successful, then I would have to look into other tribunals to see whether the mechanism could be transposed to other services. It may even be the case that other tribunals already would like a power to refer questions to themselves that they lack the jurisdiction to answer, but I'm not sure about that still.
At that point, though, your question becomes a tribunal's question rather than a charitable question.
Yes. Thank you.
Final question.
Thanks, Craig. I have two actually, but it's
That's
only
fine.
brief, so I won't detain you too long. The first one is for Brett, and it just sort of builds on John's earlier question in relation to the section 325 referral mechanism. Can the Attorney General veto that, or is there a statutory checklist whereby the Attorney General can actually say it's a vexatious referral and therefore I'm going to veto it? Or how does that referral actually work when one has to obtain the sanction of the Attorney General? And my second question is for Renate, is that correct?
Renato.
All right. Just in relation to this particular doctrine, if I can call it DP, it has its origins within a civil law code, and if I'm correct, you're hoping to transpose it onto the Brazilian system, which is also somewhat similar in the sense that it's a quasi-civil code or a civil code also, which underpins the Brazilian model. And it sort of builds on John's earlier question also. Is this particular doctrine, is it specific only to civil law countries, or can it complement the well-established framework which exists within common law in countries where we have that well-anchored division between general damages and special damages on the other hand? So my question is it a useful, can it be transposed onto common law countries? Because my understanding of it is it comes from, it emanates from civil law codes. That's my question.
Okay, so Brett's response first.
A brief response, I think. The Charity Commission must ask for the Attorney General's consent if it wants to refer a question. The Attorney General can just say no. I'll look into that further, but as far as I know, it can just say, no, I do not give consent. And that's essentially a veto power.
And would he have to outline the reasons for the refusal?
Possibly. I wonder if without a reason, is the Attorney General a public body? Might be reviewable. But I'll have to consider that further.
And Renate's response?
I don't think it's a very basic doctrine. I don't think it's based in civil codes. We have also a civil code in Brazil, and that's quite new. It's from 2002, but have a lot of mixed heritage from. We got some things from the big B, and but we also a lot of things from the code, the French code, and some influence from Italy. So I think we got a very mixed civil code, but none of the biological damages, none of that is really related with some article, a specific article in civil code from Brazil or also Italy. The discussion began in the 70s in Italy because an article, I think it's 2059, that related the non-patrimonial damages to legal prescription. So it's just, I think, that the beginning of the discussion, and we didn't have that problem in Brazil when they didn't have that problem in Portugal, but that didn't stop the development of this idea. I think the influence of those juridical orders stopped in Brazil in the 70s, as we have a personal damage idea that's very close to the corporal damage, that also include the work disability. So I think that's not founded exactly in the civil code. The biggest problem is the discussion about what are the damages that the tort law should pursue, and I think that's the biggest problem. And every civil code have this kind of problem, because for example, in Portugal and Brazil, they didn't describe exactly what are damage. We have this juridical relevant damages that should be awarded in Brazilian law, and in Portugal, it should be the damages that are result from injuries to juridical interested protected interests. So I think that maybe could be transposed to the common law also. I think that I read something from Alexander Sant'Stio from Oxford that talking about the Tabelle di Milano, and that's he wrote something. I think so that he wrote something that it's not a huge problem to compensate this money equally in some standard forms. So the maybe the use of these tables and could be something that could be developed also in the United Kingdom or other common law countries, but that's not really my area. So I think that we don't have any obstacle to applying that kind of theory in Brazil, but we don't have nothing developed in that matter. We just have some decisions that use the term, use the expression that's very that's not so different. It's just a biological damage. So they pursued they award some damages in the name of that are just sometimes are quite another thing, but they are also damage to the body. But it's not that idea of danno biologico, that because they put everything in the same basket and call it non-patrimonial damage or moral damage. I think that this idea to specialize the damage, to divide it, I think that's something that we can use in Brazil, and maybe common law should be something that could be studied. But in my small research in English library in Reading, I didn't saw anything quite directed to that. But maybe something that could be developed from the common law perspective, because I don't think that is founded in the civil code. But of course, as it's a head of damage, we should discuss the idea of damage that is awarded in the Brazilian, Portuguese, and Italian tort law. And so I think that it's a very common problem to the civil law countries that have civil codes to define what are the damages. I think that's just the link that we have.
Thanks, Brendan.
Okay. Well, thank you.
Okay, so I'm sure Brett and Renato would be happy to discuss this further if anybody has any other questions over lunch. But could everybody thank our speakers for 2 great presentations today? I don't know if I was supposed to formally present these to you, but there's some certificates. Thank you.
You shake your hand in front of the camera.